Order number 14, motion. Exercised by the Deputy County Governors of the powers and functions vested in the office of the County Governor in the absence of the substantive holder of the office.
Senator Ledama Olekina.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, I beg to move a motion exercised by the Deputy County Governors of the powers and functions vested in the office of the County Governor in the absence of the substantive holder of the office. Mr. Speaker, sir, that cognizant that Article 179(4) of the Constitution designate the County Governor and the Deputy County Governor as the Chief Executive and Deputy Chief Executive of the county, respectively. Further, cognizant that, pursuant to Article 186 of the Constitution, a County Governor and Deputy Governor are elected on a joint ticket with Article 179(5), providing that whenever the County Governor is absent, the Deputy County Governor shall act as a County Governor. Aware that in several counties, Deputy County Governors have had to serve as County Governors due to the absence of the substantive County Governor arising from ill health, incapacity, or orders emanating from the courts barring the substantive governor from assessing office. Acknowledging that Section 32(4) of the County Governments Act places limitation on the exercise by the Deputy County Governor while acting as Governor of the powers to nominate, appoint, or dismiss that are assigned to the Governor under the Constitution or the written law. Noting that, other than the said limitation, under Section 32(4) of the County Governments Act, no other restraints are placed in law on the exercise by the Deputy County Governor of the powers and functions of the Governor whenever the Governor is absent. Aware that, in exercising the powers and functions of County Governor, pursuant to Article 179(5) of the Constitution of Kenya, Deputy County Governors face a myriad of legal operations and administrative challenges which hinder the effective functioning of the county governments and the efficient delivery of services to the public. Now, therefore, the Senate direct that the National Treasury, the Control of Budget, the Auditor General, and the respective county assemblies and the County Executive Committee members to work directly with the Deputy County Governor while exercising the functions of County Governor in order to facilitate the effective functioning of county governments and the effective delivery of service to the public. Mr. Speaker, sir, the biggest challenge that we faced in this country...
Order, Senator Olekina. I see from the documents before me here...
As amended. I wanted to, when I conclude, I was
Order, Senator Olekina. I'm sure you don't know what I'm about to say. 100% sure that you don't know what I'm about to say. However, I can see some paper trail here that you have actually amended your motion without saying so, which is in itself irregular. No, you should say, I beg to move the following motion in an amended form. That should be the opening sentence. That's number one. Number two, that amended form, irregular as it was moved, is not supported by the version approved by the Speaker, which causes a technicality. As you are aware, the standing orders provide that if you want to amend your motion after it has been put on the order paper and notice has been given, that shall be approved by the Speaker. So the version approved by the Speaker is not the version you have read. And therefore, you have two options. Option number one is to move the motion as approved by the Speaker. Two is to seek approval of the Speaker, which will not be instantaneous because it requires the Speaker to reflect on the amendment and move your motion once approved by the Speaker at a later time, including tomorrow. So the choice is yours, mover.
Mr. Speaker, sir, I appreciate your intervention. One of the challenges that I faced is that the version that I signed is not the one which was brought here. So I was actually at a loss because when I signed the document, it was sent. If there were any amended format, I could have at least been told that that has been changed. So that's what confused me. So, Mr. Speaker, sir, I would like to seek your indulgence in moving the motion in an amended format. If it is possible for me to do so, where I'm standing. The challenge is because tomorrow I'll be attending another function at which the Speaker is the one who has requested me to represent.
But also, as you know, Senator Ledama Olekina, the approval of the amendment has to be consistent with the law, the standing orders, practices, and etc. So, resume your seat for a moment, and I'll give further directions in a short while. So, Senator Ledama Olekina, as I said, the implication of your amendment require reflection by the Speaker. However, I am looking at the standing orders. The standing orders allow the chair to allow a senator to move a motion in amended form if the amendment does not materially alter the crux of the motion. Therefore, whereas your amended motion, which actually amends one word, changes the implications of the motion, I am convinced that it does not materially alter the crux of the motion. However, this determination is particularly on this motion as crafted and does not apply to all motions where similar words and similar amendments shall apply. Such other proposals for amendments where the words involved are similar shall be determined by the Speaker on a case-by-case basis. And therefore, having said so, I direct that you can move your motion in an amended form as proposed. Proceed. And because you had done so, you don't have to repeat it.
Thank you very much, Mr. Speaker, sir. Mr. Speaker, sir, I really appreciate you allowing me to move this motion in an amended format. Mr. Speaker, sir, the genesis of this motion is really on what is happening with the development of different court rulings which are coming up in this country. We're at a time where we in this House develop legislations which are supposed to protect particular offices, but somehow we forget that there are other consequences. They always say choices have consequences. Article 179(5) of the Constitution of Kenya states as follows, Mr. Speaker, sir, that whenever a county, and I'll read it, when the county governor is absent, the deputy county governor shall act as the county governor. Subsequent, Mr. Speaker, sir, Article 180 of the Constitution is very clear. It clearly states that a governor and a deputy governor are elected on the same ticket. Now, in this country, we find ourselves, Mr. Speaker, sir, in a situation where we have the courts, which is one arm of government, coming out with very clear orders that a governor who has been elected by the people cannot have access to the office. Mr. Speaker, sir, this governor is the same governor who appoint CECs and CEOs. When he's not, and you know, we're in an environment where politics dictates and loyalty also rules in this country, Mr. Speaker, sir. So you find that in Kiambu County and Samburu County, these two counties, the citizens of those two counties are suffering, Mr. Speaker, sir. And it would be very wrong for us in this House, who are the people who are elected to defend the county and its government, to just sit and watch. So, Mr. Speaker, sir, when the County Government Act was enacted, I am of the view that certain things were overlooked. Although the Constitution prohibits a deputy governor from carrying out certain functions like, firing, CCs, or those people who were elected by the governor, when he's acting as a governor, nothing else stops him from reshuffling them. Because currently, we have a lot of problems in this country, Mr. Speaker, sir. There are so many pending bills, procurement laws have been violated, the PFM Act has been violated. So when a substantive governor is in office, Mr. Speaker, sir, some might even argue that everyone who is given business is someone who is close to that governor. All of a sudden, Mr. Speaker, sir, when the deputy governor now takes charge because of the courts or maybe illness of the governor, that deputy governor or acting governor cannot do anything. So, Mr. Speaker, sir, I decided that it is time that we clarify this. Because when people suffer on the ground, because the deputy governor is just there, the deputy governor, Mr. Speaker, sir, having been elected in the same ticket with the governor, is not a flower girl or a flower boy. Is a person who stands there to represent the people. We saw very well that in Bomet, when the Lord decided to take the substantive governor who had been elected, the deputy governor came in and took charge. So I think in this situation where we know that in this country, because of challenges either with the judiciary, because of challenges either with the budget, sometimes some matters in court will not be decided expeditiously. It will take a very long time. So should we wait for 5 years to lapse, before a matter can be determined? And at the same time, should the people of these two counties, Kiambu County and Samburu County, continue to be dictated upon by a governor who is sitting outside the fence? So, Mr. Speaker, sir, I think this House has a very good opportunity. Because and I sit in the Public Accounts and Investment Committee, when we call the control of budget to ask questions about certain things, they're always quick to say the governor should be giving you the right answers to this. But now, when you have a deputy governor who is acting as a county governor and cannot be able to give us the answers because he's being seen just as a flower girl or a flower boy, then we are really putting this country in jeopardy. So, Mr. Speaker, sir, I don't wish to belabor on this matter, but I think reading the Constitution and also reading the County Governments Act, nothing prohibits a deputy governor from carrying out functions which were being carried out by the governor, except those which were clearly indicated there in the Act. So, Mr. Speaker, sir, I beg to move this motion in an amended format and request Senator Madzayo to second it.
Senator Justice Madzayo.
Asante Bwana Spika kwa kunipatia nafasi hii, na mimi pia ningependa kuunga mkono na kusecond hii motion ya iliyoletwa na ndugu yetu Oledama. Katika kizungumkuti hichi cha kwamba naibu wa gavana atakuwa hana mamlaka, ama katika harakati ya kwamba atachukua ofisi nusu awache nusu, Bwana Spika, tunaona ya kwamba imeleta hali sintofahamu. Kwa hiyo hii hoja hii ni muhimu ili iweze kufafanua kiukamili ya kwamba gavana kazi yake itatoka hapa, itaishia hapa, naibu wa gavana naye atatoka hapa, ataishia hapa. Kwa sababu ikiwa itaambiwa ya kwamba wakati wa uchaguzi itakuwa hawa wawili watasimama pamoja, na sheria inakuwa wazi ya kwamba, tena sheria hiyo ikilazimisha, manake inatumia shall, ambao kisheria tunasema ni lazima itekelezwe hivyo. Bwana Spika, hii inamaanisha ya kwamba ikiwa naibu wa gavana atakuwa yuko ndani ya ofisi na hana mushkili yoyote na mambo ya kuzuiwa kuingia kwa ofisi, iweze kuruhusiwa wakati gavana aliyeko katika mamlaka ako katika sintofahamu zake za kwamba yuko ndani ya ofisi ama hayuko. Hivi sasa pia tunajua kwamba mahakama imeweza pia kusema ya kwamba magavana fulani na fulani wasikaribie maofisi. Lakini tunaelewa kwamba hivi siku hizi hata simu zinaweza kutumika ama mitandao inaweza kutumika. Na gavana hata akiwa yuko Ulaya na kote mwambia asiwe karibu na ofisi, vile vile ikiwa ataachiliwa yeye kwamba naibu wa gavana hana kazi maalum ya kufanya isipokuwa pengine kunywa chai saa 4, kuenda mahali kuna hadhara ambao anaenda pale ukaongee nao, ukitoka hapo ingia gari, utapewa askari, utapewa petroli, utapewa ofisi, utapewa chai na kila kitu. Itakuwa si haki ya mtu wa kiwango cha naibu wa gavana kuwa kama mtu ambaye hajijui mbele ama nyuma. Kwa hiyo tunasema ya kwamba vile ambavyo imeletwa na mageuzi yake iweze kuchukuliwa hivyo hivyo, na mimi naunga mkono. Asante Bwana Spika.
Order members, I propose the question that cognizant that Article 179(4) of the Constitution designates the county governor and the deputy county governor as the chief executive and deputy chief executive of the county respectively. Further, cognizant that pursuant to Article 186 of the Constitution, a county governor and deputy county governor are elected on a joint ticket with Article 179(5), providing that whenever the county governor is absent, the deputy county governor shall act as the county governor. Aware that in several counties, deputy county governors have had to serve as county governors due to the absence of the substantive county governors arising from ill health, incapacity, or orders emanating from the courts, barring the substantive governor from accessing office. Acknowledging that Section 32(4) of the County Government Act places limitations on the exercise by the Deputy County Governor while acting as governor of the powers to nominate, appoint, or dismiss that are assigned to the governor under the Constitution or other written law. Noting that other than the said limitations under Section 32(4) of the County Government Act, no other restraints are placed in law on the exercise by the Deputy County Governor of the powers and functions of the governor whenever the governor is absent. Aware, in exercising the powers and functions of county governor pursuant to Article 1795 of the Constitution, deputy county governors face a myriad of legal, operational, and administrative challenges which hinder the effective functioning of county governments and the efficient delivery of services to the public. Now, therefore, the Senate directs the National Treasury, the Controller of Budget, the Auditor General, and the respective county assemblies and county executive committee members to work directly with the Deputy County Governor while exercising the functions of County Governor in order to facilitate the effective functioning of county governments and the efficient delivery of services to the public. What is it, Senator Samson Cherargei? You're on a point of order?
Yes.
What is it?
Mr. Speaker, sir, I need the guidance from you as the chair on very critical issues. I have seen my brother and Senator Ledamo Lekina has tried to raise the issues of running of counties, which is important. But, Mr. Speaker, on the issue that we need to a ruling on, to remove a governor, Mr. Speaker, there are grounds that have been set out under Article 180, 181 specifically, that there are 4 of them, either resignation, removal from office through judicial process, incapacity, or death. All these issues that the Constitution has raised, Mr. Speaker, sir, this motion by my good friend Senator Ledamo Lekina purports to say when a governor is charged or is facing charges in a court of law, the powers that is vested upon the office of the governor or the governor himself will cease but would be transferred in courts to the deputy governor. My question is very simple, because this issue of governor and the presidency can be extrapolated. And I want your ruling, Mr. Speaker, on this motion, because what it means that is, there is what the next principle, Mr. Speaker, sir, is the principle of presumption of innocence. If, for example, we say the governor of Kiambu or the governor of Samburu, Mr. Speaker, because he's facing anti-graft charges in a court of law, is being charged, does that mean by the fact that you want to install Deputy Governor Nyoro to be the governor and have all the powers that has been limited by the drafters of the Constitution, and the Constitution is supreme, does it mean, or in quotes, give a verdict that the governor who is facing charges is guilty? Thirdly, Mr. Speaker, I have seen the reliance on a subsidiary legislation. The senator of Narok should be aware that the Constitution is supreme. You cannot attempt to rewrite it except on 2 grounds, either popular initiative or parliamentary initiative. What Senator Ledama Olekina, Mr. Speaker, sir, wants to do, he wants to rewrite the Constitution.
Are you debating or you're on a point
No,
of order?
I'm raising three critical issues to seek your guidance. And
I have heard you say,
yes, please.
Senator Charagai,
Yes.
that what Senator Olekina's motion is suggesting or proposing for adoption by this House constitutes to a backdoor effort to remove a governor from office otherwise than what is provided for under the Constitution.
Correct, Mr. Speaker, sir.
Then you've made your point. What is the other? You have an extra.
Another point, the second
Yes.
point, Mr. Speaker, sir,
Yes.
was on the presumption of innocence.
Yes.
Because by the fact that you are saying...
Does this motion presume guilt?
No,
Is
but
that
by
your-
the fact that you want to confirm a deputy governor to have the whole powers of a governor who is facing graft or other charges in a court of law, it means you have already passed a verdict of guilt.
Would you like to
against
be
that
informed by the owner of the motion?
No, I don't want to be informed.
Order, Senator Charagai. Okay, your final. Do you have another ground for position?
My final issue, Mr. Speaker, sir,
Yes.
and you being a professor of law, with of course illustrious career, the ruling I am seeking is that there is over-reliance on the aspect of a legislation which is, the Constitution should be supreme. Senator Ledama tries to rely on a legislation which is an act of parliament. He is attempting to rewrite the provisions of article of the Constitution, Article 180, 181 and 182 on the issue of removal of government. And I'm saying, Mr. Speaker, as I conclude,
Yes.
there are two ways of amending or rewriting the Constitution.
Yes.
The issue of parliamentary initiative or popular initiative. And therefore, I'm seeking your indulgence
All right.
and a ruling on this matter,
All right,
Mr. Speaker.
Senator Charagai.
Yes.
Senator Ledama Olekina. You have been challenged.
Mr. Speaker, sir, I respect my colleague very well. But sometimes it is wrong for a colleague to jump into a matter without really reading the motion. Mr. Speaker, sir, this motion is relying 100% on the Constitution and not on the substantive legislation. If, Mr. Speaker, sir, my dear colleague, Senator from Nandi, would have been listening to my submissions, I made it very clear that the difference we have is where these governors, deputy governors, have not been restricted by the Constitution to carry out certain functions, unless, apart from those which are clearly indicated in the Act. Mr. Speaker, sir, if you look at my motion, which I hope that my dear brother would have read, it is very clear. I said, acknowledging that Section 32(4) of the County Governments Act places limitations on the exercise by the deputy county governor while acting as governor of the powers to nominate, appoint, or dismiss that are assigned to the governor under the Constitution of the written law, nothing else. So what I'm saying is that there are certain limitations which are very clear, and I've acknowledged those, Mr. Speaker, sir. I'm saying the deputy governor has not been limited or restricted from reshuffling. The Constitution gives him that power. Article 179(5) gives the deputy governor powers to act as the governor when a substantive governor is not in office. I am not suggesting that when a court of law in this country has made a ruling that now we have more powers than the court of law. All I'm saying is that the court of law has already barred these two gentlemen from accessing the office. So if they have been barred from accessing the office, should we also just sit and watch as they run the county governments outside? Mr. Speaker, sir, we live in a country where a telephone can make all the decisions. And when the county governor is not in office, as it is the case in Samburu and Kiambu, those people are suffering. So, Mr. Speaker, sir, I would like to clarify to the distinguished senator from Nandi that I am not in any way attempting to bring in a deputy governor as the governor through the back door. All I'm saying is this. Now that the court has barred them from accessing their offices, they cannot purport to be running the county governments outside their offices. We need services to continue. And since both the county governor and the deputy governor were elected on the same ticket by the people, And since this constitution gives the deputy county governor powers to act as a governor, of course with limitation, nothing else, Mr. Speaker, sir, have they been restricted from carrying out.
No, Senator Charagai, you already raised your point of order. And I heard you clearly. Unless you want to give supplementary information, because the issues you have raised are extremely heavy constitutional issues, which the chair must address himself to. What is the supplementary information?
Mr. Speaker, sir, while I was trying to use courtesy of your office, we have modern equipments. I'm trying to get the ruling on the matter of the issue of deputy governors and their powers to act by, I think, Justice Mumbi Ngugi. I want to draw your attention, Mr. Speaker, even as you retreat into your Solomonic wisdom on this matter, to raise your issue on Article 179, Sub-Article 7. The argument that Senator Ledama Olekina wants to perpetuate is that when a governor is facing charges or allocation of charges, or when a deputy governor, Section 7, Sub-Article 7, if a vacancy arises in the office of the county governor, the members of the county executive committee appointed under Clause 2B cease to hold office. Does it mean by the time the governor is facing charges in a court of law, does it mean that that seat is vacant, and therefore we have a governor, Mr. Speaker, sir, who by all purposes should reconstitute the county executive and the running of the county government, as envisaged by Article 179, Sub-Article 7?
Senator Charagai, you're trying to debate matters which are not before this House, which are out there. You're trying to debate matters about particular issues, particular cases, particular counties, particular governors, particular deputy governors, which is not the subject matter of this motion. This motion is about giving effect to the functions of a deputy governor who is acting as governor in the absence of the substantive governor by operation of the law. However, you did raise an important issue about whether a court order which has restricted, and I think part of this is also in the motion, or even in the words of the mover, a court order that has restricted the presence, the physical presence of a governor, that would amount to, giving effect to the governor not being able to perform his functions. Now, for me, that's the main issue. These other issues about, they are neither nor here. We should not discuss particular cases. This motion actually is not even discussing any particular cases. I know the mover did mention examples of current cases, but the motion in its text is general and is on points of law. So we should apply the Constitution, the applicable statutes, which the motion has tried to do with a lot of, I'm actually impressed, and the Constitution, the statutes, and where possible, our standing orders. Now, I see Senator Kajwang. Are you on a point of order, or you wanted to debate the motion? Same with Senator Omatangi. Now, Senator Charagai. Senator Charagai, out of your very well detailed point of order, the thing that I have picked that is important for the House is whether this motion meets the constitutional test on removal from office of governor. Because if it doesn't, then it means the motion is unconstitutional. and the Senate cannot pass an unconstitutional motion. What is it, Senator Kipchumba Murkomen, Majority Leader?
Mr. Speaker, I was following the debate, though I was from somewhere in Nakuru, where a friend of mine lost their brother.
Sorry about that, Majority Leader.
Sorry for coming late. Mr. Speaker, I have a fundamental problem with this motion. And my fundamental problem emanates from the place that says orders emanating from the courts barring substantive governor from accessing office. Mr. Speaker, the fundamental argument here is for us to ask ourselves as the Senate. First, the debate is out there whether the courts can bar any governor from being a governor in the first place.
Whether they can remove a governor from office
Yes,
through a court order.
Through a court order. And the reason why I'm saying that is that there is a decision to be made by courts. I'm aware. I may not bring the proceedings here to the floor of the House, but there was a case of the governor of Samburu, Moses Kasaine, where the courts issued an order barring him from holding office, and then they have appealed it in the Court of Appeal, and a ruling is in a decision of the Court of Appeal will be made anytime before next year. There was a case of the governor of Kiambu, Waititu, the same. And again, it will happen to all other governors if that was to be the president, in terms of where courts where they are facing corruption cases, because this House has made a lot of, in a committee chaired by Senator Moses Kajwang, they have made tremendous and serious recommendations to be implemented by EACC as against many governors for matters related to corruption. The Speaker, the question that this House should be answering is, can a court do so? And can we legitimize, therefore, through a motion, that which is unconstitutional? The Speaker, from my personal position, without interfering with what's happening in the courts, I don't believe that when someone is a suspect, there is any provisions of the Constitution from page 1 to the end that says the president can be suspended from office, or Mr. Speaker, that a governor can be suspended from office. And the danger, Mr. Speaker, if you allow me just 2 more minutes, the danger we are facing as a Senate is that we have been elected, and I really wish senators can take this seriously. Article 96, we've been elected to defend and protect the interest of counties and county governments. You have a national government that has control of DCI, the Office of the Director of Criminal Investigation. You have a national government that has a big say on the Office of Ethics and Anti-Corruption Commission. You have a national government where the president has the constitutional responsibility of appointing the DPP. Now, Mr. Speaker, the most dangerous one is the DCI, because DCI is just a policeman appointed under the National Police Service.
A police officer, not policeman.
A police officer, yeah.
Can be a lady.
Yeah, because it can be a lady. So, Mr. Speaker, there is a danger here. Where national government has a fight with counties, whether political or ideological, like it has happened in the past, the danger is for this House to legitimize a process where charges will be brought against any governor, and Mr. Speaker, as a result of those charges, they are told you must stay out of office for 5 years. This is a constitutional coup, Mr. Speaker, and this should be in principle. And I want to say this, I know my governor is under investigation, tomorrow is appearing before EACC, whatever EACC makes that decision, but Mr. Speaker, there's one thing I don't agree. I will not believe that, Mr. Speaker, it was intended in the Constitution that when a governor is charged for misappropriation of funds or all that, they must leave office, including the governor of Elgeyo Marakwet County. So the fundamental argument I have with this is, Mr. Speaker, the question of, Mr. Speaker, well, the part that says deputy governor has been, and governor has been barred from holding office. Now, which begs the question, accessing office, yeah. I mean, in the principle is so. Now, Mr. Speaker, which principally is, which in my opinion, is the fundamental position of this motion, is what we call the substratum of this motion. In the absence of that provision, the last paragraph becomes superfluous, because automatically, where a governor has been given by his deputy, that a deputy governor has been given in writing by the governor, like in the situation of Bomet before the late governor of Bomet passed on, she had given in writing the deputy governor, who is now the governor, the powers to act. And there was no problem with the ministries concerned in terms of dealing with the issues, because that one is already provided for in law. It becomes superfluous to talk about government ministries cooperating with a governor who is acting legally, because in any case, it is legal. The reason why this motion is being brought up is where there is a gray area, and that gray area is where the court order can bar a governor from holding office. Mr. Speaker, I beg my colleagues, and even if it's possible, I have been asked in this House when you are sitting in the chair to withdraw a motion, which was a constitutional amendment. And Mr. Speaker, if I really beg my colleague, Senator Olekina, whom we sit together in the Senate Business Committee, that to allow room to ventilate this issue and for you to give a proper ruling on that particular issue, Mr. Speaker, we should stay the debate for the time being until the Speaker gives a proper ruling on that particular constitutionality of that position. Because then the substratum of this motion will be lost if we don't deal to that matter.
Order, Senator Murkomen. Senator Murkomen. Hold on, Senator Kajwang. Senator Murkomen. I would like to invite you to help the House. Does a court order asking a governor not to physically access his office amount to removing that governor from office? Is it your view that a court order issued directing a governor not to physically access his or her office, is that a removal of that governor from office, whether temporary or permanent?
If you look at the court orders, Mr. Speaker, related to the deputy, because if you read this part, it says, or orders emanating from the courts barring the substantive governor from accessing office. Mr. Speaker, office of the governor is not the building. So if you say you are not accessing office of a governor, is constructively, because that is the case with the Kiambu as we speak, and Samburu. Constructively, it means, Mr. Speaker, that even an office of the governor of Kiambu in Thika, because office of governor is performing that function. It's just like if you say a judge should not access his office. Mr. Speaker, where is the office of a judge? A judge is a judge even when he's in a car park, Mr. Speaker.
Even in his house.
Even in his house. Even anywhere.
Remember in the olden days,
that is
a judge could give you orders in the olden days, even from his house on Sunday.
Absolutely. So constructively, the definition, first of all, of what's an office of a governor is in doubt. I mean, it's in question. Mr. Speaker, does that even include that the governor should not perform his functions, like appointing a CC, sacking a CC, signing papers for purpose? If that is not true, if that is not what this motion is intending, Mr. Speaker, in fact, thank you, Mr. Speaker, that has just come to my mind. The answer to your question is in the last paragraph. The mischief that is being cured, Mr. Speaker, that's being cured in the last paragraph, which is to work directly with the Deputy Governor, which is, Mr. Speaker, that the Controller of Budget, the Auditor General, and respective county assemblies and county executive committee members to work directly with the Deputy Governor while exercising the function of county governor in order to facilitate effective function. Meaning, the governor is unable to do all those things. Meaning, therefore, Mr. Speaker, it is not the physical office. Meaning it's not his physical presence that is being challenged here. It is performance of his function as an office of a governor, as an officer in that office. If that was not the case, then there was no need for the last part. Because the Speaker, he can still sign letters. Somebody can do the documents in whatever location.
Senator, so that we make progress. And
he can still, yeah.
And by the way, Senator Olekina, I want to thank you. This is a very important motion because, and the SBC, I also thank them for scheduling it, because this is addressing current challenges that devolution is facing today. And if there is a house where this should be canvassed, is here. So the motion is good, but allow us so that we make a very objective, impartial, and nearly perfect finding as a house. Allow, just jot the notes. We'll give you a bit of time to respond to anything that has been said. You don't have to interrupt. Senator Murkomen.
Thank you, Mr. Speaker. So I am even concluding that, in effect, this motion is answering your question in the last paragraph, that such governor who has been barred from accessing his office is unable to do all these things, unable to work with CCs, unable to work with, Mr. Speaker, various national treasury, control of budget, auditor general, meaning that if it was signing documents that go to treasury, if accessing office was just physically accessing office, not his functions, anyone would have taken documents to governor's house to sign the documents when required. Meaning, Mr. Speaker, this motion is alluding to what is already happening out there, where the governors are being barred from performing the functions of a governor constructively.
Follow-up question, quickly.
Yes, Mr. Speaker.
Is when a court of law says a governor should not access office, does that mean a governor should not perform the functions of that office?
Mr. Speaker.
Because my understanding is that the orders were about accessing office as a criminal suspect or as a suspect of a criminal process, not to attend the office, which is where the alleged crimes
took place.
Mr. Speaker, and not the suspect being told you cannot perform your roles because you're a suspect.
Mr. Speaker, I'm giving you this information, and I'm willing to supply the House further information once actually collected from the proceedings of the High Court. Mr. Speaker, in both cases of Kiambu and because decisions have already been made, it's just being appealed, but in the decision that has been made, Mr. Speaker, it's been interpreted by the courts to constructively mean inability to, barring him from performing his functions. And I'm saying so because if it was about evidence, it would have meant protecting the information that is there for purpose of prosecution, which, Mr. Speaker, cannot be indefinite. The courts would have given the DCI or DPP, say, 6 months to collect all the data they want, then this person can go back to the office. But if you see the indefinite nature of even those orders, it means, therefore, that it's not about the evidence that is being collected. It is continuing to act as a governor to avoid him from running the affairs of constructively. That's what I'm saying, constructively, from the order itself, that has created that opportunity. The danger I have as a senator in this house, the danger I have, and it's slowly going to come. Senator Orengo said on the floor of this house when we were debating the same issue about barring governors, and when he was disagreeing with that order barring governors, he said that we may be laughing at governors, but it comes slowly. Soon you will be told a member of parliament should be barred from accessing his office. Yeah, Mr. Speaker, and then you wonder what is that accessing of office vis-a-vis eight sittings.
No, you're right, Majority
and
Leader.
So forth.
You're right, because there are some members of parliament who have been charged with criminal offences,
Absolutely.
so it should not be seen as a purely governor's
thing. Yes, Mr. Speaker.
Very well. I remember Justice Ngugi, Mombi Ngugi, just to give you further areas of reflection, did actually in the process, in a short sentence, give our views that certain parts of the law were unconstitutional, and wondered, 62, and wondered, because it tries to cushion governors from what we are discussing here. And she even wondered, in her reasoning, she said she thinks, though that was not canvassed before, she thinks that section is unconstitutional because it is contradictory for somebody who has been accused of plundering resources to be asking to be allowed to exercise functions about administration of the same resources in the same county where the accusation has been made. Meaning it has to do with the charge and not the evidence. It has to do with the person, as the fact that the person has been charged and not the evidence. Yeah, one last time so that I hear Senator Kajwang. And I'll give the mover ample time to respond to all the interventions.
Mr. Speaker, it must be remembered that in this country we don't have a jury of some sort, yeah? That the threshold, there is no pre-trial to determine threshold. So the threshold for one being charged, yeah, can be as low as the decision of the DPP sitting at that particular time. And Mr. Speaker, the collection of evidence, this House, neither the office of the governor, doesn't have control. So there is no place where evidence is being sieved. By the time, Mr. Speaker, someone is ultimately now being going through trial and cases are being dropped on the way, some evidence is becoming apparent, Mr. Speaker, the impact on the citizens is so high. Let me give this example. If you look at Kiambu and Samburu, Kiambu, for example, the quantum that the governor is going, the actual quantum that he is dealing with, Senator Wamatang will help me, I don't know if it is 50-something million, yeah? That is directly, the total amount, the contract was said it was about 500 million, but the amount that is being accused of is about 40 million himself that came to his account. 20-something million, I think, I'll confirm.
Sir, about 20 million.
Just imagine, Mr. Speaker,
yes.
Now, I'm not saying that there is a smaller sin or a smaller crime, but theft, imagine.
Yes, theft is theft.
The impact of maladministration in Kiambu contributed by that decision. When the governor is not office, just imagine the impact in terms of service delivery in such a county, or Samburu. Samburu, where already the deputy governor and the governor again are fighting. Kiambu, the same. The Speaker, we are going to create a very dangerous precedent as a House if we are going to be part and parcel of this.
Okay.
And therefore, since the courts will make the decision, this House also will have to make a decision thereafter.
Very well. Thank you. In fact, this House doesn't have to wait for the court to make a decision. We are empowered also to, as protectors of devolution, make our own decisions in accordance with the applicable laws and standing orders. Senator Kajwang, what is it?
Mr. Speaker, I've been struggling to contextualize whether the debate is really a point of order or a point of debate. But because
it's a point of order which raises a point of law. Which point of law affects debate of this motion?
Allow me, Mr. Speaker, in light of the submissions on the point of order by the two distinguished senators, to also bring to the attention of the House that the Constitution, Article 179(5), talks about when the governor is absent, and the word there is absent. That is 179(5). And then you go ahead, Article 182 talks about vacancy in the office of the county governor. And Mr. Speaker, my view, not being a legal scholar, but being average when it comes to English, is that absence and vacancy are two different things. Mr. Speaker, vacancy has been clearly defined in the Constitution. Article 182. The office becomes vacant as a result of death, resignation, impeachment, or imprisonment for a term exceeding 12 months. Mr. Speaker, this motion does not address vacancy, because where there's a vacancy, there are clear procedures for succession. This motion addresses absence. And the reason why this motion comes up is because the Constitution does not define what constitutes absence. We have taken a fairly narrow view because we have focused on the issues that were prompted by Justice Ngugi's ruling on issues of state officers. When they are charged, then it means that they have some ill health and therefore they should stay out. There are court orders, Mr. Speaker, that could legitimately lead to the absence of a governor. If you look at Article 182(1)(d), the office of a governor becomes vacant only if the governor is charged and sentenced to imprisonment for a period exceeding 12 months. What if a governor was imprisoned for 8 months, Mr. Speaker? Is that a vacancy or that's an absence? In my view, that is absence. And if a governor would be in jail for 11 months, Mr. Speaker, shouldn't we as Senate then provide directions and guidance for the deputy governor to step in, not as a substantive governor, but as an acting governor because the governor is absent. Secondly, Mr. Speaker, there are cases of illness. In my county of Homa Bay, my governor has been ill and it has been in the public domain. Indeed, even appearances before the Public Accounts Committee have been deferred because the governor has traveled. That is absence, that is not vacancy. Finally, Mr. Speaker, and this happened in this republic when the president was going to the Hague, and that was construed not as a vacancy in the office of the president, but as an absence. Mr. Speaker, I think we need to allow this conversation to continue, this debate to go on, and probably what we need to focus on is a definition of absence away from the clearly defined circumstances of vacancy that are already in the Constitution. And if anything, Mr. Speaker, the ruling by Justice Ngugi has been described as obiter dictum by some of us, and as rightly been pointed out, it affects state officers. Governors are state officers, senators are state officers. It is a matter at the Court of Appeal. We probably might want to not to limit ourselves to the issues that arose in that particular ruling, but look at this matter broadly. There are many circumstances that will lead to absence of a governor, Mr. Speaker.
Actually, Senator Kajwang, you've started with a disclaimer that you are not a lawyer, but I think you've done fairly well. Fairly well. If it was in my previous life, I would have recommended you for an award of a certificate in legal philosophy or thereabouts. But now I do not have that capacity. Let me ask you, Senator Kajwang, quickly. According to you, absence is caused by the physical inability to perform functions, while vacancy is caused by legal incapacity to perform functions. I understand you correctly.
Mr. Speaker, the use of inability is tricky because that then is impeachable.
Because absence, for example, an order of an office is abroad, is absent. So physically, there is a physical limitation of performance of duty, and therefore they would appoint a deputy to act. Okay? But vacancy implies legal incapacity, meaning that office is vacant, and therefore the person holding that office has no legal capacity to perform those functions. So, for further reflection, then we hear Senator Olekina and close that matter. Because you are Senator Kajwang. And thank you for reminding us, Senator Judge Ngugi's observation was obiter dicta, which is important. So it was not part of the matters conversed before the court, but it's thought-provoking though. So I have one last clarification to ask from you, Senator Kajwang. Don't you think, therefore, if absence connotes physical inability to perform functions, it means, therefore, a court order, in my view, which limits the governor's capacity to perform functions by saying the governor cannot access office, which office can be the physical building, or it can be interpreted broadly to mean the actual performance of those functions from wherever, as is the case in Kembu. Don't you think, therefore, that definition of absence that limits the governor from performing functions actually technically moves that issue towards creating a vacancy of a temporary nature or thereabout? Don't you think so?
Mr. Speaker, indeed, I will not claim to have a direct answer, but in my consideration, and having listened to the challenge that you put before us, I would say that absence is therefore determined by the office bearer. in the example that I gave of the president traveling to The Hague, and he decides that I'm going to be absent, and therefore my deputy shall assume that, and it was done symbolically. Therefore, Mr. Speaker, absence shall be determined by the governor himself. And, Mr. Speaker, the challenge then...
Can court determine absence?
Mr. Speaker...
Can court determine an absence which amounts to limiting the functions, the performance of functions of governor?
Indeed, Mr. Speaker, assuming...
Or should it?
Assuming that a governor...
Going by the,
yes.
Your distinction between vacancy, which I found very impressive, vacancy and absence, going by that, when the court says you can't access office and therefore, according to what we are discussing, the governor cannot perform those functions, whether temporary or permanent or long-term or short-term, don't you think, therefore, it's no longer the governor determining that absence, is a court? And where does that leave us when you look at the grounds for creating vacancy, as you rightly put out? Is either somebody was not qualified to stand for governor, or resignation, or death, or a conviction, which is a judicial determination of conviction and jailing someone for more than 12 months. Food for thought, you don't have to answer now. You are still on your feet. Maybe you can wind up your thoughts.
Mr. Speaker, not really to answer, but just to provoke further thought. And this is a conversation we have had even within my committee. Under Article 182(1)(d), that conviction to a term exceeding 12 months, what happens if a governor is convicted to a term of 10 months, and the governor then determines that while he's in committee, he's still able to continue exercising or discharging his duty?
That is permissible by law.
Are you going to forcibly remove him? And that is why
you can't. The same way for a member of parliament, it is 6 months. If the member of parliament is jailed for less than 6 months, they don't lose their seat. There is no vacancy.
Indeed, Mr. Speaker. So therefore, it will fall on the governor himself to make a determination that his 10-month jail term is going to prohibit him from executing his duty. And that goes back that in the case of absence, there has to be an agreement between the governor and the deputy that indeed I will be absent. It cannot be directed by other quarters.
Or by court.
Or by the court. The court can only direct a vacancy rather than an absence.
So in the Kiambu and Samburu cases, has the court declared a vacancy or an absence, in your view?
Mr. Speaker, in the Samburu and Kiambu cases, the courts have not declared a vacancy. In my view, the determination of the courts could lead to an absence, but it will fall upon the governor to say that being barred from accessing office will limit my functions as a governor. And so he will then appoint or delegate his duties to the
Senator
deputy.
Kajwang. Well done. So, sorry, colleagues, we've run out of time, and Senator Olekina, we don't want to appear as if we have to make a determination that helps us move one way or the other. So unless there's a burning issue, I want to ask Senator Olekina to just say a few things in reply, and then I'll make a ruling. How many minutes do you require, Senator Wamatangi? Because really, this is a point of order. This is a point of order.
Mr. Speaker,
how many minutes do you need?
I will try to make them...
No. How many minutes do you need?
I can do with 15.
I give you 3 minutes, Senator Wamatangi.
3 minutes, Mr. Speaker, it will be a bit short.
Thank you for for bringing the light note, but I'll give you three minutes.
Mr. Speaker, can I indulge you to allow me also to have my take on it, just like every other...
In 3 minutes.
Thank you, Mr. Speaker. First, I wanted to allude to the fact that, Mr. Speaker, this House was seized of this matter even before it became a court struggle. And in the last session of Senate, we attempted to come up with legislation
Mr. Speaker, and you remember when you were the majority leader then, in defining what the functions of a deputy governor should be. But then that law never saw the light of office, Mr. Speaker, and how I wish that was done, because maybe this would have been dealt with. Point I wanted to make here, Mr. Speaker, is the presumed vacuum in law, Mr. Speaker, indeed does not exist, in my view. It does not exist. The law has addressed itself to all those questions, including the questions you're asking Senator Kajwang on absence and vacancy. Mr. Speaker, but let me first, for clarity, because this matter, Kiambu County is one of the counties that are affected. So it is important to clarify that, to my mind, it is clear that when a governor is facing charges, or when there is doubt on the conduct of the governor, Mr. Speaker, that indeed it is in order for a governor to be charged in a court of law. And that cannot be prevented by all means, Mr. Speaker. And so, once a governor is charged, the process, Mr. Speaker, of how the court determines the guilt or innocence of that person must be followed to its finality. But the point I wanted to make, Mr. Speaker, then, with the volumes, Mr. Speaker, that you're asking is on those two issues, Mr. Speaker, that you asked. On the question of absence and the question of presence, Mr. Speaker. First, Mr. Speaker, the question of absence of the governor is addressed in Article 179 on that subsection 5, Mr. Speaker, where the law says that when the county governor is absent, the deputy governor shall act as the county governor, Mr. Speaker. And that is on the question of absence. And Mr. Speaker, in reply to that particular provision, Mr. Speaker, the law has expressed itself on what happens then. In the County Governments Act, Mr. Speaker, in subsection 32, in section 32 of the County Governments Act, Mr. Speaker, the law has defined precisely what should happen. And that is why I think the remedy or the mischief that the motion was trying to cure the mover would be probably best cured by an amendment of the law. Because Section 32 of the County Governments Act says that when acting as contemplated in Article 179(5) of the Constitution, the deputy governor shall not exercise any powers of the governor to nominate, appoint, dismiss, or that are assigned to the governor under the Constitution or within the written law. Mr. Speaker, I don't know whether we collaborated with you, because I see you have a lot of interference. This is a question you asked. The point I wanted to make very clear is on that question of absence, which is addressed in Article 179(5), which says that the county governor, in the absence, the deputy governor acts. That answer is provided for very clearly in the County Governments Act, Section 32. It says that when acting in the office as contemplated in Article 179(5) of the Constitution, the deputy governor shall not exercise powers of the governor to nominate, appoint, or dismiss that are assigned to the governor under the Constitution in Article 179(5). That is provided for. So there's no vacancy or any lacuna in law to ask how do you act when there is absence. Number two, Mr. Speaker, is on the question of a vacancy, which is also clearly defined as to how a vacancy arises. It's also answered by the Constitution.
Okay, so what is your position?
It is answered, Mr. Speaker, by a process of assumption.
So what is your position on the point of order?
Mr. Speaker, in mine was a contribution, not necessarily a point of order.
Yes, so what is your...
And my position, Mr. Speaker, is, like I've said, in agreeing with most of the views that have been aired here, Mr. Speaker, by my colleagues. One, I have expressed my concern that in the process of charging a governor or any other person, that can be undertaken. But on the question of should a vacancy be assumed by the fact that a court order has been given, and then that is predicated to mean then that the effect of when a vacancy has occurred should be assumed, Mr. Speaker, my answer is I do not think that's the right way to go.
All right. Thank you, Senator Olekina. As briefly as you can, it's in your interest because...
Mr. Speaker, sir, I have listened to the contributions by my colleagues, but I'm baffled because in this House, we are the house which is tasked with protecting the interest of counties and its government. And devolution being a new baby which is crawling, there are so many things which are unique in their characteristics. This is what in law is defined as sui generis. This is a situation where we have found ourselves that a court of law, which is another arm of government, has barred these governors from accessing their offices. Mr. Speaker, sir, if you read the decision by Justice Mumbi, she equates this to these governors having been accused of committing a moral illegality. Something, the term she used is moral ill health, which means she's not saying I'm barring these people from accessing their offices entirely, but it's for the duration of the trial, what they have been accused of. Mr. Speaker, sir, what we are seeking to find here is a solution where we have got a county governor barred from accessing his office. And this is why I differ with the majority leader when he says that a governor can perform their functions outside the office. They can't. Because when you look at the circumstances that led for that governor to be barred from accessing that office, is that what the judge called moral ill health. But in this case, Mr. Speaker, sir, I'm not focusing...
No, that's okay, but those words by Justice Ngugi were obiter dicta, meaning they had not been canvassed and they are not binding in law, actually, to be honest with you. It's
I agree with
to provoke thought.
My issue,
but you can rely on them in that persuasive manner, but not binding.
My issue, Mr. Speaker, sir, a governor could be admitted in a hospital somewhere in this world, away, and they stay there for a period where is not defined or determined.
Like was the case in Bomet.
The case in Bomet. What about the public interest, Mr. Speaker, sir? What about the services of people who have got to get certain services delivered to them? Mr. Speaker, sir, apart from a governor, even the president is not referred by the Constitution as a CEO. But when you look at a governor, he's being referred as a CEO. Every single legislation out there looks at a governor as a CEO. If you look at, Mr. Speaker, sir, if you look at other parastatal bodies that we have in this country, where a CEO has been found, has been asked to step aside during criminal proceedings, that person has not been removed from that office. In the case of Kenya Pipeline Corporation or Kenya Power and Lighting Company, those two CEOs were asked to step aside from their office. And a temporary CEO was put in place so that you do not interfere with the services being provided to the citizens. So, Mr. Speaker, sir, I would like to request my colleagues that because of public interest, not politics here. And Mr. Speaker, sir, we have to be seen as a house of reason. I want us to divorce politics from public service.
Order, Senator Ladama. You should not impute improper motives. I don't, unless you have proof.
Mr. Speaker, sir.
That there has been politics by any particular senator. Because I have not had any politics myself.
True. All right. I take that back, Mr. Speaker, sir.
Thank you.
I think the key most important here is that this is a unique situation that we have found ourselves. And I would like to plead with the majority leader to really think about the merits of this matter. Hypothetically, suppose we change the word being barred from accessing the office by the court, a court order. What about if a person is out there ill and they cannot be able to access the office? You'll get your time. I think you should be patient enough because...
Let him finish. Let him finish. Yeah.
Mr. Speaker, sir, this is a matter of public interest. It has got nothing to do with the position of a governor. Maybe in future, some of us might aspire to be there. But what we are looking for, Mr. Speaker, sir, is continuity. People in Kiambu are suffering. People in Samburu are suffering. Maybe another governor somewhere would fall sick. Even though the law does not spell out what should happen, I think it behooves us as the House of Reason to be able to come up with something, something that come in between. We've heard, even from the submission from my colleagues, that whatever is bad from being, the deputy governor is not supposed to either dismiss, appoint a new CC. All I'm asking is for you to see the logic behind continuity and public interest, Mr. Speaker, sir. So, Mr. Speaker, sir, I would like to stop there and request that this matter proceed, this motion proceed, and then we can vote for it. Even if it calls for county governments to vote for it, so long as all of us would have been given an opportunity to try and ensure that this country maintains a fiduciary responsibility. It is very sad, Mr. Speaker, sir, when you hear deputy governors out there arguing that.
Yes.
Now that the substantive governor is out, because I've been watching, Mr. Speaker, sir. I've been watching the Kiambu deputy governor speaking. I've been watching other people talking in the media. I've heard the Samburu deputy governor speaking and saying that now, whatever changes they want to effect, the CCs are taking orders from the governor out there. So, Mr. Speaker, sir, it is about time. And I want to end by saying this. Yesterday, a couple of days ago, Mr. Speaker, sir, when we were debating the issue of raising the interest, the debt ceiling to 9 billion, I used a quote here, which the President said. The Chief Justice should go and sit down with him and discuss. I think it will get to a point where even the Speaker of this House would find some time to sit down with the Chief Justice and the President, because they are the leaders of the three arms of government, and discuss and say, what happens in a situation like this? This is a unique position. We in this House, as a House of Reason, must come up with a unique solution to it. I thank you, Mr. Speaker, sir.
Yes, Leader of Majority.
Mr. Speaker, I didn't want to come back, but my colleague provoked me to focus on the merits. And Mr. Speaker, I want to assure you that my submissions are based on merit and really on something I believe in. And even as you make your decision, remember we are being invited by this motion to act notwithstanding. The motion in paragraph 1, 2, 3, 4, paragraph 4 acknowledges the limitations to the functions of county deputy governor and goes ahead to go down there and say public officers should work with the deputy governor directly, notwithstanding legal limitations. Mr. Speaker, which in my opinion is an amendment by the back door using a motion, Mr. Speaker, to amend their constitutional. Because if you say, for example, deputy CC should take orders from the deputy governor and should be moved, appointed, transferred, for example. I'm just saying the question for transfer.
It's not in the motion.
No, not in the motion.
It's hypothetical.
Yeah, hypothetical. This
Yes.
is not in the motion. Mr. Speaker, if you say, for example, deputy governor should be moved from one department to the other, that is taking an order. If Mr. Speaker should be given additional assignment, that's taking an order from the deputy governor. The question is that order or directions, for example, going to comply with the constitutional requirements? So the point we must be also careful to appreciate is that telling National Treasury, Control of Budget, Auditor General, and county assemblies and to work directly with the deputy governor, Mr. Speaker, is akin, and this is a blanket directive by the House. Mr. Speaker, then where is the limitation where there is a legal and constitutional limitation? Because
But I thought it's captured in the motion. One of the paragraphs there talks about county government tax.
Yeah, it just says notwithstanding, recognizing. Just recognizing.
It just says they can do, this deputy governor who is acting as governor,
Yeah.
that's my understanding, I
Yeah.
could be wrong, can do all that is empowered to do except the limitation. Maybe it's the English.
I assume.
That
Maybe
is
the
my
drafting
understanding.
itself, that would be inferred. But
Very
Mr.
well.
Speaker, the last paragraph just says, therefore, work with the deputy governor on everything.
Working is just working. I mean, working is, there is no harm in work. All right. All right. Senator Cheragai, you... Yes, make it very brief. Very brief.
Just 1 minute. I have listened to Senator Olekina's relied heavily on what Justice Mbuguki said, which he relied. In fact, in the statement, she said the orders they were giving was not to remove the county governor. And he went ahead to rely on Swasuri case in terms of authorization to access his office. So in this instance, the absence of a governor to an office is created or is being control access by the courts, because in that Swasuri case, in that case, Mr. Speaker, they had said before the chairman of National Land Commission could access the office, they must get authorization from the CEO of ethics and anti-corruption. And that is the matter that Justice Mbuguki was ruling was on the governor of Samburu, Mr. Speaker, sir. So I thought we should get it a difference. It was not per se the removal.
So, Senator Cheragai,
Yes.
are you saying that therefore that clarification means that the absence created for the governors in question was physical absence that had nothing to do with their function?
Because
and even that physical action could be supervised. I mean, the physical presence could be supervised as in the case of Swasuri. Is that your view?
That is my view, but interestingly enough, Justice Mumbi Ngugi questions the same, that is it practical enough for in occasionally or more time and again for the CEO of ethics and anti-corruption to be giving authorization for the governor. But in my own opinion, the creation of absence of a governor is not only physical, but in terms of functionality of his office, Mr. Speaker, sir.
Okay. All right. Senator Olekina, approach the chair. Sorry, colleagues, for that hiatus. As you will realize, I have allowed a lot of intervention. You know, points of order are normally procedural issues. They should not take a long time. But what has happened this afternoon is that the point of order by the Senator for Nandi, Senator Cheragai, raised extremely weighty and complex constitutional and legal issues. the interventions and observations that arose from that point of order, from all the senators that have spoken, including the mover of this motion, have even brought out the complexities in a greater detail, in a greater manner. And therefore, it will be some form of injustice to, in a cavalier manner, dispose of this matter without looking at all these aspects, so that this House can help the country move forward and help devolution and help. We could even, the courts sometimes have a lot of regard for the other arms of government. We could even help courts to try, because they do not have the monopoly of knowledge, try and understand, because we are the lawmakers. They just interpret what we make. They can help the court even understand the mind of the lawmakers, so that they can help this country interpret the law. And therefore, I have accordingly consulted with the mover of this motion. And I want to give, having listened to all the senators who spoke, whom I thank profusely, and having had some consultation with the mover, I direct as follows. We proceed as follows. First, I direct that because motions are timed, the time that has been consumed in canvassing the point of order by the senator for Nandi County shall not and should not count towards exhausting the time set for debate of this motion. So it freezes the time. Okay? Having said so, honorable colleagues, I direct further that debate on this motion proceeds, and I'll say why. The reason is that because this matter is so weighty, the more senators articulate themselves on this issue, the more clarity and the more the chair is able to clarify in his head some of these issues, to be able to offer proper guidance, because this issue is best dealt with exhaustively when it is hot and live, and when a situation like this has arisen. Because of, again, of that directive, I therefore direct that debate continues, but no voting on this motion shall take place until the Speaker has retired and considered carefully all the constitutional and legal issues and provided a well-reasoned ruling. And it is upon that ruling that this House will decide whether or not, because if, for example, hypothetically, if the motion is found to be within the constitutional limits, as the mover and other senators like Senator Kajwang argued somewhat, then we can vote on it, and it will be a binding decision of the House. And before voting, no business of this House is binding until a vote has been taken. But if, on the contrary, as has been the view by Senator Cheregai, the Senate Majority Leader, Senator Murkomen, and a few others who spoke, if the motion is found to have overstretched itself and infringed on any aspects of the Constitution, then the Speaker will direct what happens to such a motion, because this House cannot pass an unconstitutional motion. Therefore, having said all that, debate continues. The usual time that is allocated to the motion will apply, but no division on this matter, no voting will take place until the Speaker makes a well-considered ruling. And finally, this is a very complex matter, and I have consulted with the mover. We have agreed that the Speaker's ruling be issued in 7 days' time. Thereafter, depending on the ruling of the Speaker, these issues in this motion should help this House, and I've recommended to the mover or any other senator to take this matter forward into bringing legislative proposals that can help the country address this matter in a more clearer and positive way. Thank you very much. So ordered. Therefore, the ruling will be on Thursday next week. Thursday next week at 2:30 p.m. So continue. Where were we? It had been moved. Oh, it's now as the question been proposed. Okay. So now, Senator, the last speaker was. The seconder was from. The seconder was Senator Mazayo. So Senator Abshiro.
Thank you, Mr. Speaker. I rise to support this motion. Mr. Speaker, sitting and listening to the interventions so far, perhaps it's my non-legal mind, but I did not see a single reason why we shouldn't have continued with this right from the beginning. It looked to me a very reasonable, a very practical, a very administrative motion that perhaps didn't have to go so deep. But again, as I said, I'm not a lawyer, and perhaps and that's why. But from reading the prayer that the Senate recommends National Treasury and other arms of government to work directly with the county governor while exercising functions of the county governor in order to facilitate effective functioning of county governments and the efficient delivery of services, I stand guided, but I found that very reasonable request and very reasonable prayer by the mover to ensure that services to the people are not disrupted. Mr. Speaker, under the article that gives us the mandate, the point of devolution or the point of us protecting counties and their government is not an end in itself. It's so that services are provided to the counties and to the people. So if then the job of a governor and his deputy is to provide those services, I did not see why not. Why should we then not give those in the spirit of accountability and in the spirit of sharing of the responsibilities, having run on the ticket as a team? Why not give those powers to the deputy governor? Mr. Speaker, stories are told of governors, of spouses of governors actually coming to stand in for the governors sometimes. And I know in my county once a story was told of the spouse of a county governor coming to say, well, the county governor is absent, but I am here, and therefore these are some of the things that he would like us to do. And so I think it's only fair that the office of the deputy governor is also recognized as part of, the executive, and therefore bearing responsibility, as opposed to then having somebody who is absent from office giving orders. If somebody was to hold somebody accountable, if the people of that county were to hold their leadership accountable, who would that leadership be? Because even in a court of law, if somebody says the decision, the direction was given to me by somebody who is absent, how would we go ahead and hold him accountable for whatever that is going to happen at the county level? So I think this motion is timely. This motion seems very reasonable. This motion looks to me, anyway, from where I sit, as in line with good governance in terms of what needs to happen in an organization, especially if we look at our organizations as systems, processes, resources that collectively then provide services to our people. I don't see why then we should create a vacuum just because somebody is absent, yet there's a deputy that takes money from us, from the taxpayers, there's a deputy that is there in all purposes, but then what are we saying? That we should hesitate to give him the responsibilities and continue to leave a vacuum when we can do something about it. Mr. Speaker, when Judge Ngugi, and I don't want to go back there, or any other judge bars somebody to physically go to one, I do not believe it's the physicality that is material. It is actually everything else to do with that office, because when there's a very good reason why you're being barred from going to that office, so that you don't perhaps tamper with evidence, or you don't exert undue influence on people that ideally report to you. So I don't think it's a physical aspect. It is the whole functionality, is the whole hierarchy, is the whole respect that comes with your office as a governor that then has a bearing on the functions, and therefore perhaps would then give you undue advantage if you continue to stay there. So the issue of physically being there, I think, is neither here nor there. It should be that the function that you're supposed to not, continue to exercise. So, Mr. Speaker, I support this, and while we talk of constitutional provisions that give the governor a lot of weight in terms of exercise of power, I think that even if not specifically spelled out in the Constitution, by extension, the office of the deputy governor does have or does enjoy or does have those responsibilities as well, and therefore to leave it in limbo, I think, is a disservice to the people of the counties. Mr. Speaker, so I support, and whereas we say that we speak of limitations, and even in those limitations, that I think the spirit of this motion is not to say that is not at variance. It's basically saying we respect those limitations, but that said, we want to cure the vacuum that exists, and I think that is what I understand by how the text reads, and from what the movers and the seconders have mentioned to us, Mr. Speaker. Looking at my county, for instance, county of Isiolo, our governor is not absent, but even when governors are present, there's the whole issue around the deputy county governors that this House needs to deal with. And for me, why I like this motion, as much as it doesn't take care of the continuum of all the issues that face the deputy governors or the executive of counties, it does take care of the immediate need that we see happening in some of the counties as a result of what has been given in this motion. So, with those few remarks, Mr. Speaker, I see this motion as a reasonable one that has reasonable prayers, that then also makes us utilize the deputy governor and give him some responsibilities, because after all, we take care of his, we pay the county deputy governor as well. With those three remarks, I support, and I think and one last one is that, Article 96, which says we, as Senate, are supposed to protect county governments. That protection should be looked at from as Senator Olekina has said, from the interest of the people, from the interest of the public, not just the government itself, because a government is not just an end in itself, but it's there to serve the people. I support, Mr. Speaker.
Thank you very much, Senator Moses Kajwang.
Thank you, Mr. Speaker. I rise to support this motion. Mr. Speaker, the long illness of President Garfield in the United States led to much discussion and different shades of opinions on what constitutes a disability in the presidential office which will justify the vice president to assume the duties of the president. Mr. Speaker, yes, this was a conversation about disability. And as we have stated earlier, that this motion is not about disability or inability of a governor to carry out his functions, because that is impeachable. But this discussion around President Garfield, and later on there was an American president who died, In 1804, there was a 12th Amendment that then came up with clear procedures on how assumption of office would be undertaken in the event of a vacancy in the office of the president. And so part of the interesting debate, Mr. Speaker, was that the legislators at that time were asking themselves, if the vice president assumed office because of the inability of the president, should the vice president be called the president, or should he be called the vice president, exercising the powers and duties of the president? And Mr. Speaker, that is a question that we'd also ask ourselves. In the case of Kiambu, would the deputy governor go around calling himself the governor? Or he would call himself the deputy governor exercising the powers of the governor?
Is that acting governor? Is that equivalent, the last part, is it equivalent to acting governor?
Well, Mr. Speaker, if you are elected to be deputy governor, and then you, in the absence, you act as governor, I don't have the answer, Mr. Speaker. I don't know whether you should call yourself a governor or acting governor. Yet the title and mandate that the people gave you was deputy governor. And Mr. Speaker, as you've rightly pointed out, that this is an interesting matter that we cannot just debate in one afternoon or 2 hours and render an opinion on. And I really welcome your assurance that further thought will be given to this matter so that we are able to provide direction to the country. As I said earlier, in my county, my governor has had an illness, which, because he has admitted it in public, I am at, I think I can talk about it now, because he has not hidden it. Recently, when he came back from treatment, he said he had temporary blindness, but he can now see. He had a long period where he was out of the country seeking medical attention. And Mr. Speaker, there are those who felt that the deputy governor ought to have taken over while the governor was absent. And I think that there's need for some restraint. As it is now, a governor can be sick for 5 years. There's no recourse. We have not made any provisions. The governor is a chief executive officer. He's the only state officer who's described as a chief executive officer. Mr. Speaker, is it feasible for a CEO of an organization to be on sick leave permanently? Definitely not. For public officers, there are clear procedures. If you are unwell, which is human, and there's nothing wrong with it, it's not a sign of weakness, you will be given medical leave. And the duration of medical leave is defined in the public officers' HR manuals. When you exceed a certain duration, you'll be asked to proceed further on further medical leave, but chances you'll be on half pay. When you exceed maybe the 100-day mark, Mr. Speaker, you might be asked to step aside, for lack of a better word. I'm talking about what happens in corporate. Because if you are unwell and unable to exercise your duties in the office, it will not be acceptable that you remain unwell forever and remain on the payroll forever. And this is a lacuna, and it is upon us to deal with it. And I do hope that this motion is going to prompt that conversation. But as it is, a governor can be unwell permanently, and he can be re-elected while in the hospital bed and be unwell for another 5 years. And as you said, does that constitute incapacity? Mr. Speaker, incapacity arising out of ill health must be certified by a doctor. And the governor must subject himself. He must take himself to the doctor to ask the doctor to certify him whether he's fit to hold public office. Or he must be compelled by the assembly through the procedures laid out in the Constitution to undertake a medical examination. There is a reason why in the United States of America, presidential candidates are required to declare their health status so that the nation knows the kind of person they are electing. Mr. Speaker, I support this motion because under such circumstances, when the governor, due to ill health, is unable to continue running the county, he could make a decision, he could make a determination on his own volition and say that because I'll be going to India or Germany for treatment, I hereby appoint my deputy to act as per the provisions of the Constitution. The other situation is where a governor is jailed for a term less than 12 months. And Mr. Speaker, the 47 governors in this country, they are a representation of Kenyans. And I don't believe that 47 governors equal 47 angels. They are wrongdoers. They are those who are currently facing criminal charges. They are those facing charges of murder. They are those facing charges, some of the most gross charges you can ever imagine. Mr. Speaker, what if they are committed to jail for 10 months? How do we ensure these counties continue operating? I would shudder at the thought that a governor would be chairing a cabinet session at committee. I would shudder at the thought that a governor would be signing documents delivered to him at committee. Mr. Speaker, those are situations that must prompt the governor to appoint or to designate the deputy to continue running that office. Mr. Speaker, I believe that we have a duty, and I don't know whether it will be the devolution committee or whichever committee it is, that governors as CEOs must be subjected to certain procedures that have been applied in the private sector and in the public sector, so that absence as a result of illness is not permanent. Absence as a result of a jail term less than 12 months, there can be clear provisions. Finally, Mr. Speaker, the appeal should not just be to constitutional commissions. Even in cases where a governor who has been charged, for example, the case of the governor for Samburu, the problem is not the independent and constitutional commissions that are not cooperating. The problem could be the assembly. The problem could be the cabinet. We were just told a story today of a deputy governor who has attempted to reshuffle his cabinet, not sacking anybody or appointing a new person, just saying that you've been in sports, now I want you to be in agriculture. You've been in education, I want you to be in finance. I don't think that is illegal. Of course, these are matters that are before the courts of law. But you'll find that the CECs themselves will go to the media and say that they do not recognize the deputy governor. So this appeal, yes, constitutional bodies will cooperate, they will comply, but if the people around them, the people who are supposed to exercise and implement the decisions of that deputy governor assuming the duties of a governor, if those people do not recognize the deputy governor for that role, then there would still be a paralysis. Mr. Speaker, finally, the issue of impeachment, we have set a very high threshold, and Mr. Speaker, we have not successfully impeached anybody with the exception of Governor Wambora, who went to court and got orders, and as far as you're concerned, Governor Wambora was impeached. Where there is incapacity, Mr. Speaker, we need to make sure that the procedure for impeachment, by the time that matter comes to the Senate, due process has been followed, a governor has been given an opportunity to defend himself, and this is why I must call for the fast tracking of the impeachment procedure bill, which I'm told is stuck in the National Assembly. It will provide better clarity and it will help us to deal with such situations, such that when a governor is facing certain problems, instead of having someone acting and the problem persists, then the Assembly can take decisive action and make sure that someone who does not have such challenges is given the opportunity to run the county. Mr. Speaker, it is embarrassing for a county to have a governor who appears in the dock to answer to charges of murder. I don't think that that governor would be representing the interest of the people living in that county. I support, Mr. Speaker, but also subject to the clarification that you'll be providing as you had promised. Thank you.
Senator Cheruiyot.
Thank you, Mr. Speaker. Mr. Speaker,
less than 1 minute, but
I rise to oppose this motion. I will give the reasons later.
Okay. Order, members, order. Order, members, when we resume, order. When we resume debate on this motion, Senator Aaron Cheruiyot will have 15 minutes to give the reasons for opposing this motion. Secondly, order, senators, the mover of this motion And I thank you for your accommodating the House and the Chair. Said he will not be in tomorrow. I would encourage him, this motion to be put on the order paper when he's in on Thursday, to allow him follow the proceedings. Very well. Honorable Senators, this is now 6:30 p.m. Time to adjourn the House. The Senate therefore stands adjourned until tomorrow, Wednesday, 13th November 2019 at 2:30 p.m.